I zoom in a little bit? 1, 2, 3. Yeah, I can make this higher though. Oh, maybe this is as tall as it goes. Yeah, it's lower.
Can you move it up more, maybe?
Mm-hmm.
That would move it up as far as you can. Just like...
I will. Flopping. Yeah, exactly. Good job.
Can't hear? Okay, well, I'll leave it for somebody. Can you hear me now? Okay. So welcome. Thank you for coming. As you know, this is what we refer to in the business as the week of 9/11. So we thought we would commemorate it with a look back at where we've come in terms of terrorism prosecution. As you know, the Center on National Security spends a great deal of its time looking at prosecutions across the country, sometimes out of the country, and trying to figure out what is being done to make us safer, whether or not the government is reassuring people that they are keeping us safer, and at the same time not overreaching in terms of rights, liberties, and constitutional protections. This has been a very long and complicated conversation that's been going on since 9/11, since that morning, and one that I think has been very constructive, where law enforcement, often at our events and certainly in their real world, real life, has listened carefully, for the most part, to critics, and so libertarians who have often been patient about things that they really don't want to be patient about. So my hope is that we can have this conversation going forward, but I thought we would start today. One of the interesting things that you should know in terms of terrorism prosecution is that there have been, depends on whose count you go by, but I go by our count, which is that there have been almost 400 terrorism prosecutions. Those are individuals prosecuted under terrorism statutes or for terrorism-related crimes since 9/11. What's really interesting about this is that these numbers, which range anywhere from 25 to 40 in any of the years of the first decade after 9/11, are somewhat decreasing. And if you take out the cases that are currently getting a lot of attention, the high-profile cases of individuals who are accused of lethal attacks against the United States, like the embassy bombing cases that are downtown this fall, you will find that there's even fewer cases than we've had on an annual basis. So, however, Attorney General Holder has let this country and Europe know that he is very interested in prosecuting anybody who thinks they're going to give their aid to certain groups in Syria and that will be involved with supporting ISIS. And I think you're going to see a lot of interesting realignments between the communities and interests represented here at this table and how they respond to the threat of ISIS. So I think this is a good moment to begin to think about what the United States has done to counter terrorism using prosecution and what it might think about doing going forward. And so that's the reason we're having tonight. It's a new panel. I mean, normally we just have the same people over and over. We have a bunch of new people tonight, so I'm very excited. And I will introduce them very quickly, and then we will get started. To my immediate left is Seth Descharmes. He's new to us, as I said, but the most important thing about Seth is that he went to Fordham Law School. And the other most important thing about Seth is he's the deputy of the National Security and Cyber Crimes at the Eastern District of New York. And I don't know if you know this, but the courthouse in Brooklyn, the federal courthouse, has taken on the lion's share of terrorism prosecutions over the last 5 or 6 years. It has worked very closely with Main Justice, has worked closely with JTTF, and has done a number of cases that if someone were going to write a history of terrorism prosecutions, they would do well to spend a lot of their time focusing on Seth's courthouse. And I assume you've participated in some of those cases. Okay. To his left is Andrea Prasso. Andrea is the Deputy Director of Human Rights Watch in the Washington office. But actually, what she didn't put in her bio, and what we didn't add because the list would have been too long, is that she's the author of a number of Human Rights Watch reports, all of which are, I recommend that you will go on the site and find them. This one in particular that she wrote recently, I think it was released the 3rd week of July, is about terrorism prosecutions. And it's somewhat critical, but it also has a number of interesting analysis of just what makes up a terrorism prosecution and how to think about it. And I think there are copies outside that she brought along, and I urge you to pick one up. To her left is Linda Burrito. Linda, I'm so happy to have Linda here. And yes, and we have her because of the terrorism trial that's in New York, and so she happens to be here for the next few months. She's a defense attorney that has represented a number of terrorism defendants over the past decade and more. And currently, she's has a defendant in the embassy bombings trial that will be starting later this fall that I referred to down at the Southern District of New York. But she's also represented Semi Al-Arian, who I'm sure you've heard about, and if you haven't, maybe we'll get to some of that today. Afia Siddiqui, who recently has been in the news, and a number of others. And so she has a broad perspective on any trends, developments, changes in terrorism prosecutions over the past decade plus. And finally, John Dolan, welcome. His first time here, he's the acting assistant SAC in New York at the JTTF. He's been working on terrorism crimes since before 9/11. And I think there's something to be said about the individuals, whether they were journalists, national security people, FBI agents, or others who really got to know terrorism, some defense attorneys who got to know terrorism before 9/11. It brings a perspective to the table, a depth to things, an understanding of what the threat is, but also of what the threat isn't, that can sometimes be sorely missing. So we are really excited to have him. And actually, we're going to start with you.
Okay. Again, John Dolan. I'll start by just giving you an idea of the role that I fill within the FBI's Joint Terrorism Task Force here in the New York office. I'll go a little bit into an overview of what we've done as far as changing since 9/11. The Joint Terrorism Task Force is broken up in 3 divisions right now. We have a Branch A, a B, and C. Basically, Branch A, the one that I cover right now, is responsible for our home operations for the city and 6 counties north of the city and Long. So we do a lot of the. Can you hear me back there? Yeah, do. Turn it now. Anything? Yeah. I'm gonna yell. Is that better?
Yes.
Perfect. So the way it's broken up, so we have the operational aspect for things here that occur in the city and surrounding boroughs. Branch B, where there's another assistant special agent in charge who handles our extraterritorial matters. A few of my colleagues in the room here work on that. Branch B, Frank Pellegrino, for one, who's sitting right to my left. And then there's Branch C that does a lot of our WMD and our special tactics type activities. As far as the Joint Terrorism Task Force, as Karen just mentioned, I started working terrorism matters in 2001, just before 9/11. As a matter of fact, Frank Pellegrino was my training agent back in that day, so I just want to mention that because he's a lot older than me, and I want to make note of that. We've grown physically. That's one of the things that I'll mention as far as the numbers are concerned. We started off with relatively few squads prior to 9/11 that were working counterterrorism. And at the time, if you can recall, counterterrorism matters were strictly a law enforcement situation. We dealt with counterterrorism just strictly within the FBI's New York office at the time in a lot of matters. We had the only Al-Qaeda squad at the time prior to 9/11 was housed here in New York, where I worked with Frank and Mike and John Anisette. So considering the size and scope that we're at now, we have approximately about 500 plus 530 investigators assigned just to the New York JTTF. Within the New York JTTF now, we have almost, I would say, most state, local, and federal agencies here in the New York office. We are by far the largest joint terrorism task force in the nation, and we're the first. Other than that, a lot has changed as far as sharing information. We all know the 9/11 Commission report came out and what some of the do-outs were on that. One thing that we've tried very desperately and focused on as far as changing ourselves to incorporate some of the do-outs from the 9/11 Commission was our exchange of information. And the FBI was a leader on setting up the infrastructure within the United States intelligence community, pushing information to our partners. That's been a big change. I say that's the biggest change I think I've seen since I started, was the sharing of information. Of course, at the time, we always attempted to share the appropriate information, especially threats to national security to our partners. But now there's a robust and routine infrastructure that pushes that information out to the point where it's just second nature. It happens automatically. Whether it be us, our CIA, Secret Service, whatever we need to do as far as pushing that information to gain the full breadth of the resources that not only the federal government has, but just right here in the New York City area with regard to the NYPD. Another thing that's changed quite a bit, our relationship with them and attacking the threat of terrorism and using the manpower resources they have here in the New York City area. So those are a few of the things that I've seen, information sharing and just our liaisons with our partners.
I have a couple of questions I just want to ask you before we go on. One of them is just the threat level now. How would you compare the threat level now in terms of the information you're getting? Let's talk about two different things. One, in the domestic, homegrown sector, and I really mean here in New York. Let's not talk nationwide. We'll just talk about what you're responsible for. And also in terms of sometimes what you used to hear Commissioner Kelly talking about, the threat from abroad. It's how you distinguish these and how you see the threat level now as compared to 5 years ago, 10 years ago, 15 years ago. How do you see that?
Well, as far as the threat level, we're always diligent, we're always vigilant. The media drives a lot of what we see out there as far as threats. Right now, ISIS is the flavor of the month. Within the rank and file and within the corridors that we work in, we're always dealing with threats. I'll speak from an investigator's point of view, an agent's point of view. It doesn't change much for us. You're working, if you've got a case and you have a threat information that's coming in, you're working a predicated case, the threat's real and you're doing your job, whether the media is pushing out a lot of the current affairs that are going on, ISIS being one of them. But going back 5 years ago, closer to 9/11, obviously a lot of the emphasis was on international terrorism. I think we focused a lot back then on the threat from abroad, the terrorism actors abroad, the groups, the entities. I think the big challenge we have now is that homegrown violent extremists, and it's for obvious reason. These individuals do not belong to a defined group. They're not communicating to a central command. They operate in the shadows. The advent of the last 12 years, 13 years, social media has blown up. So I think people are in this day and age have the ability, sitting in their home, as we've all spoken about before, to be, radicalized, to come up with ideologies that are extreme. And that's been a big challenge. These individuals that aren't necessarily attached to a group or an entity and identifying them. Of course, we run into issues of, I guess we'll get to that later, of First Amendment and those things. But that poses a real challenge now. And I think in this day and age, because of so much media, like ISIS, the influence that group has, and some of those pictures and those videos that we've been seeing, they're powerful. And there's individuals out there that take that and push that in a direction that obviously is a concern for us as the FBI and individuals that are sworn out to protect.
Either the microphones are not on, or you have to move them closer to your mouth.
Or, yeah.
Is it on now?
No. Susan, can you?
So they'll work better if you bring them closer to your mouth or the sleep.
I don't think, is mine on?
No.
Has anybody heard anything I said? I'd rather not. Can you hear me now?
Yes.
So, for those of you who have heard what I said, so that's been the big challenge for us. I think the threat level, coming from a perspective of an investigator, it's always there for us. But at the end of the day, I think the current problem we have now is that homegrown violent extremism.
Yeah, we're going to come back to your First Amendment issue.
Okay.
But I'm going to ask you to pass the microphone to Andrea so that she can talk. We'll come back to First Amendment, and I think we'll come back again to ISIS because you seem to minimize it a little bit in terms of New York. I will come back to it,
Right.
which I think it's an interesting question. We'll come back to it. I just want to say that the Center on National Security is no longer in this building. We aren't having a lot more events here. We've moved, and as a result, I have no idea what goes on in this room. So we're just going to deal with it for tonight, and then we'll be in a new building, and hopefully things will work better. Who knows? So we'll just use this.
Should I try it?
No. Just don't try.
Is this okay?
Yes. It's gonna be fine.
Well, thank you. I wanted to start by thanking Karen and the Center for having me here and having all of us here because this sort of conglomeration of people and viewpoints doesn't happen as often as I know it should. And it reminded me to thank, before I start, the people who participated in interviews and talked to me and the researchers at the start report in the course of doing our research. Unfortunately, no FBI agents did go on the record with us, but a number of current and former prosecutors did, many defense lawyers, people who were accused of and prosecuted for and convicted of terrorism-related offenses, their families, and a lot of people in communities that were affected by the cases that we analyzed. So this report, which is called Illusion of Justice, exists because of them. And as Karen said, there are copies outside, and it's also available on our website, hrw.org. There's also a short video which is on YouTube, on Human Rights Watch's channel, and on our website, which is only 4 minutes, and this report is 206 pages. So feel free to check out either one as you have time for them. So I think that was a great segue talking about homegrown terrorism, because this report focuses on people suspected of and accused of terrorism offenses inside the U.S. Some have connections to actual international terrorism, some were accused of connections to international terrorism, but in general, the cases we examined were people who, many are American citizens or were naturalized citizens or were residents and were investigated and prosecuted inside the U.S., inside Article 3 courts, the federal civilian courts. And this project was a little bit of a divergence for me. I had been working on Guantanamo for the previous 9 or so years in a variety of capacities and looking at the human rights violations there. And not just with respect to indefinite detention, but also with respect to investigations and unfair trials. So then to closely examine federal terrorism prosecutions and see a lot of the same problems that we see in Guantanamo and the military commissions was interesting, challenging, and also very, very troubling. So I think what I'll do is just briefly summarize what is in our report. It's not going to be as brief as I would like because the report is not brief, but I'll do my best and hopefully we can talk about some of the more issues in your questioning later. So this report looks at terrorism cases inside the U.S. from immediately after 9/11 to the present. There's a geographic distribution across the US with some geographic pockets designed for a couple of reasons. One, quite frankly, is ease of research. We didn't have to look 50 states, we went to a few specific states. Part of that was so that we could investigate the impact on particular communities. So if a community had 3 or 4 or 6 terrorism-related cases over the course of several years, we could examine the impact that those prosecutions had on particularly the American Muslim communities there. It also meant that if we went to U.S. Attorney's Office or FBI office, there were several people in each environment who had worked on the cases. So that allowed us to really get a lot of information about each specific case. So we look at these cases from day one to the end. So the genesis of a prosecution, when people first come into the sights of law enforcement. And there are a range of ways that this happens. There are a range of ways it happens in the specific cases we examined, as well as the hundreds more that we didn't examine. There are some people who are identified because they are on jihadi websites. And the FBI has people who pose as participants in these websites routinely and will identify postings or email traffic that is concerning and perhaps engage those people. Sometimes people might have, someone in a community might have had a tip about someone. There's a really egregious case, the case of Rosamond Verdos in Massachusetts, who first came under the attention of law enforcement through a false tip, a false identification. And then once the FBI found him, they continued to pursue him. So we looked at the sting operations, what often people think of as entrapment. And I'm not going to talk about entrapment specifically very much because it's a specific doctrine under U.S. law. It's actually very hard to establish entrapment under U.S. law. So we do examine that. It's different from international standards. But sting operations, as most of you are familiar with, is the idea of law enforcement, either an undercover agent or an informant engaging in some sort of activity with the target, participating in the discussions of, and sometimes the planning and even execution of criminal acts. And a lot of us are familiar with the really high-profile terrorism sting operations. You read on the front pages of the paper, you know, a tremendous bomb would have gone off but for the fact that the materials were inert and the co-conspirators in a particular case were law enforcement agents or informants. So we looked at a lot of those cases, and in particular, what we found very problematic was, in some instances, the targeting of particularly vulnerable individuals. Some people who were indigent, who had really no financial resources, and would be offered financial incentives, sometimes with the knowledge of the FBI handlers, and sometimes without, which is, we acknowledge in our report. But people who were really so vulnerable that the offer of substantial amounts of money sometimes was an offer that was simply too good to refuse. And also, very, very troubling are people who suffer from either mental and or intellectual disabilities. Rosamond Verdos, who I mentioned in Massachusetts, is one of those men. When law enforcement first identified him, again by accident, there was a tip about someone in a gun store. It turned out not to be him. But the FBI went to his home, and after realizing he was not the person they were looking for, said to his father, "Your son is clearly mentally ill." Nevertheless, the FBI then sent an informant into his mosque, and the informant engaged in months of activity with him, and ultimately Verdos was arrested and pled guilty, and was sentenced to 17 years in prison. Still a very sick man, and the fact that people with these disabilities are being targeted is troubling for a number of reasons. Now, the fact that someone has a mental or intellectual disability doesn't mean that they can't commit a criminal act. Many people do. But what was troubling for us when we examine these cases is the targeting of these people who are particularly vulnerable. And then the decisions that law enforcement made along the way of investigating these cases. I had a defense attorney tell me an example of a case. He said, back in the day, when someone was doing some of the things that these targets are doing, the local police officer would call that person's parents or go to a community group and say, this kid is going to get in trouble. Someone needs to do something. Otherwise, he's going to go down the wrong path. And instead, what we've seen time and time again is that law enforcement sends an informant to engage with that person and help them down the path of engaging in criminal activity until they reach the point that they can actually be arrested and prosecuted. And in these cases with people with mental and intellectual disabilities, we saw time and time again examples where you would think, why isn't someone taking this man to a hospital? Why isn't someone seeing if there's some way to get him some help instead of sending in an informant and exploiting these vulnerabilities? So those are some of the aspects that we found really troubling in the sting operations. And it's interesting, Karen mentioned the Attorney General's priorities, including in Europe, and Holder said a couple of months ago, about a week or two before we put out a report, that these sting operations are working so well here in the US, he'd like to export them to Europe and help teach people how to catch would-be terrorists. So hopefully the European government will read our report as well and realize that it doesn't always work very well. So the sting operations are generally what leads people up to the point of being arrested and charged. The next thing we examined.
Okay, I just want to, just for the record, make something clear. The way you just said that, there are other than sting operations that lead to arrest
Yes.
of suspected terrorists.
Absolutely.
This is a part of general terrorism prosecutions.
Absolutely.
The other thing I wanted to just ask you and get your take on it is, were there any sting cases or informant cases, however you want to create the category, where you could point to them and say, that's a case that actually has some merit. That's a case that actually makes sense if you're going to do sting. Were there any? I can think of a couple in that. I'm just wondering if there's any that, in looking at this larger sphere, that you said, if you're going to do it, there's a really good model of how to do it. Anything?
I think we've done a really good job of being fair in our reporting, and we do document, and it's pretty clear that people work committed criminal acts. Of course, the purpose of this report and most of Human Rights Watch's work is to expose human rights violations. So usually we're documenting the actual violations. Hossam Smadi is a case I can think of where it's pretty clear that he was pretty eager to sort of press the button that would have blown up the Dallas World Trade Center building. However, he has clearly, I don't know the extent to which he had mental disabilities at the time that he was being investigated. He clearly does now. I get sometimes 10 emails a day from him that are largely incoherent. And a lot of his correspondence with us, I chose not to include in this report because clearly someone who needs a great deal of help. And there's, in the case file, you can see that he had a tremendous degree of mental instability. Ultimately, the judge concluded that he was competent enough to stand trial. So that process took place, but then there are these issues that we do have. But of course, we've examined 27 cases in depth, and out of whether it's 400 or 500 cases, there are probably many people who had clear intentions to and did in fact engage in criminal conduct who we should all be grateful are sitting in jail today. I mean, that's not the purpose of our report, to say that people should not be investigated and prosecuted for committing terrorism offenses or attempting to do so. And I think sometimes there's a challenge. People talk about the so-called preventive prosecutions. That's what some of these cases are. We want to catch terrorists before they commit terrorist acts. I completely support that and want that to happen too. No one wants to wait until terrorists commit terrorist acts to arrest them. We want it to stop beforehand. But the question is, are these people who are actually going to commit terrorist acts, or did law enforcement create terrorists out of otherwise innocent people? And that's what I think our report documents. So separate from the investigation aspect, we also looked at trials, and you'll hear more from Linda about what happens at trial. And we've documented what we think are unfair trial practices time and time again in these cases, including the fact that, just imagine sitting on a jury in a terrorism case in New York. Imagine what you would think about if, for example, the defendant had multiple versions of beheading videos on his computer, and you were shown those videos, versions of which none of us have seen on TV, but we know exist, over and over again in the course of sitting on a jury. And that may be a tenth of the material that you would see sitting on a jury. It's very hard, I think, for any of us to imagine how to be a completely unbiased juror in that situation, and let alone the standard jury pool in the city of New York and what people may think. So there are some real challenges to getting a fair trial that I think are inherent in a terrorism prosecution, but we also documented what we think are a lot of unfair practices by prosecutors, sometimes by judges, that make it that much harder for a defendant to get a fair trial. Interestingly, terrorism defendants actually plead guilty less frequently than other criminal defendants. And we don't have the ability to answer the question why.
Even though their lawyers often tell them otherwise.
I'm sure. It would have been helpful if we had a little bit more data to analyze. We put in the luminous Freedom of Information Act requests several years ago, and it was only after suing the Bureau of Prisons for failure to respond to our Freedom of Information Act requests did we start to get some data, which is included in this report. Another tranche of data is due either today or in a couple of days, so hopefully at some point we'll be able to analyze that and put that out for you. So we also looked at these unfair trial issues, including a lot of issues with respect to classified evidence that can make these cases difficult to litigate for all parties and also make them take a very long time. And the longer a case takes, the harder it may be on the defendant, who, to get to my final point, is often in very onerous conditions of confinement throughout the trial, awaiting trial throughout the trial and post-conviction. And those conditions can include solitary confinement. They can include severe restrictions on their ability to communicate with the outside world, including their attorneys, monitored communication, no contact visits with their families. Sometimes the physical conditions in these facilities are really just horrendous. I mean, rats and water rising and cold and sometimes harassment from guards and so on. So we've documented again what we think are human rights violations in a lot of these conditions, which also affect the defendant's ability to participate in his or her own defense. And that's something that I'm sure that Linda can talk about more. I mean, we talked to defense lawyers who would say, I spend my entire time meeting with my client talking about whether or not he can get more toilet paper or can he get a halal meal or whatever it is, and not be able to really engage with the merits of the case. And that's a problem not just for the defendant, but for the entire system, because our system is built upon the premise that the defendant can fully engage with his or her defense, have a relationship of trust with his or her attorney, and that's sort of what lets the whole system work. That's how all of these players get to participate. And if that part isn't working, it's really hard to have a fair trial. I think that's probably all of this in 5 or 7 minutes, and hopefully you'll read the rest of the details, and I really look forward to engaging with all of you on more specific things.
All right, we're going to follow up with some of that pushback. I want to contextualize a little bit. And Seth is going to make all of this make sense in the end. But Linda, can you talk a little bit about your view of prosecutions over the years and how they've changed, how they've evolved, what the frustrations are, and what the accomplishments are?
So I'm coming to you, can you hear me?
Yes.
As an eyewitness from the courtroom after being involved in about 18 or 19 of these terrorism prosecutions. Some of my testimony to you, unfortunately, is going to be redacted, which is one of the unfair issues that, as a defense lawyer, we often face in these cases. Let me just say, I began in 2003 with Professor Sammy Alarian. I like to say he was my first. And since then, it's brought me up to representing Adil Abdelbari in the latest iteration of the embassy bombing cases now in the Southern District of New York. The patterns, I just want to talk very briefly about 3 cases that I believe sort of highlight the pattern that I've seen in the last now 12 years or so. And what I see in these prosecutions, and I'm not going to talk about ISIS, I'm not going to talk about beheading videos except in one aspect, and I'm not going to talk about going after the bad guys. I'm just talking to you as a defense lawyer in an American courtroom and what we see. And what I've seen, before I started defending these cases, I had been a defense lawyer for 20 years, had done defense in death penalty cases, all kinds of cases. In these cases, what I've seen is the prosecutions go after a lot less concrete activity and behavior and conduct. It's more about what you think, it's more about what you believe, it's more about what you say. And careful who you know or who you once knew. That's what we see, that's what I've seen in a lot of these cases. The question used to be, did this guy do it? That's the question that would pose itself in criminal cases. Now it's the tyranny of small decisions, it's multiple conspiracies. Now, oftentimes, we're trying to figure out, well, what is it that he's supposed to have done? The first case that began this opinion of mine formed this opinion was Sammy Alarian. He was arrested on material support charges in 2003, one of the first cases that was tried after 9/11. He was also accused of murdering nationals abroad. What did he do? In that case, what we believed he did and what our defense was a strictly First Amendment defense. He was a very outspoken and effective advocate for the Palestinian cause. In reality, he lobbied Congress, he met with dignitaries, he was against the use of secret evidence in criminal trials. Ironically, what happened in his trial was there was the use of secret evidence. Now, to show how desperate the government was in that case, just very briefly, they actually used the evidence of a dream that a co-defendant had that was captured on a wiretap. And the dream that the co-defendant had concerned my client. It wasn't immediately clear if the government was going to present an interpreter of those dreams in that case, but you know, this was new waters for criminal defense. And when you talk about, when Andrea was talking about inflammatory evidence in cases, this was my real first experience with the evidence of unindicted co-conspirators. And she talked, someone mentioned the heading videos. Think for a moment, if you're in a case and the government can use evidence of videos of beheadings against your client that were not only not found on his computer, they were found on the computer of someone he never met. He never discussed the evidence of that, but the government claimed he was an unindicted co-conspirator. And that was the evidence, and it is the kind of evidence that continues to be used in these cases. It's not necessarily about what you do, it's about maybe who you know or maybe even who you don't know. The other example, very briefly, I'm sure a lot of people are familiar with, is the Holy Land Foundation trials that we did. And in the Holy Land Foundation cases, I believe this is another example of what the defendants believed, and also was an example of, I see, encroaching, there's less transparency, more now than ever before in these cases, in these prosecutions. In that case, for the first time, the government used an anonymous expert in their case. The identity of the expert was not revealed to the lawyers, not even the judge knew this gentleman's name. He could have been anyone. And so when you're talking about, you know, bedrock constitutional principles that we all sort of take for granted and we think appear in these cases, the right to confront the evidence against you, the right to know who the heck it is that's offering evidence against you, disappeared in that case, and I think that's a trend that we can expect. The last case that is particularly troubling is a case that I defended in Baltimore. I just want to take a minute to tell you about this case, because to me, this case is representative about, it's not about what you did, it's about what you think. And this case, and in pleadings to the court, we describe this case as a pre-crime minority report type of case. This young man had done 2 tours with the Army. At the end of his second tour, he converted to Islam, and he decided, he took his readings and his readings of the Quran very literally, and he decided he was going to do his hijrah, his obligatory pilgrimage to a Muslim country. Now, he thought about where he was going to go, and he decided that he was going to go to Somalia. Not my choice, probably no one's choice in this room, but that's what he decided. Now, he thought about maybe he'd go to Afghanistan, but Afghanistan was too cold. He thought about some other countries, but he didn't really like their diet because there was too much dairy in it. He offered, the evidence showed that he offered no passionate support of violence or of jihad. He had not made any contact with any terrorist organizations. He never obtained any weapons. He never pledged loyalty to any terrorist group or organization. He never attended a terrorist training camp, nor did he wish to, and he never sent money to a terrorist organization. But he was on his way to Somalia, and that was a crime. And he was picked off on a bus in Kenya, where he eventually was returned to the United States and was indicted on attempted material support of terrorism in Baltimore. Eventually, we got those charges dismissed against this young man, and we resolved it through a plea of an obstruction of justice. That is the case to me that it's one of the thinnest indictments I've ever seen on any kind of criminal allegations. But this, to me, was particularly worrisome, and that just happened last year. So that's the trend that I've been seeing.
Could I just ask for kind of context? You said there were about 400 prosecutions. I'm wondering how many of those were independent convictions. Give us a sense.
I can tell you that 89.5%, which is somewhat below the federal conviction rate. So, and if you want to go today, you can drop me an email. Yeah, we're gonna come back to a couple of things that both of you have raised, and I want to bring John into this, but I want to turn to Seth for a minute. It's a good thing we have somebody here from Brooklyn now that we've heard about what goes on in the country. Maybe we should just try all the cases in Brooklyn, right? But there were a couple of cases that you did. I know you're going to talk about other things, but there are a couple of cases, not that you personally, but the Eastern District of New York did, that I think speak very directly to some of the issues that have been raised. One of them is the JFK case, which was an FBI case that actually did what I thought FBI cases are supposed to do, which is to uncover a kind of a wide network of ties. You know, they tied the case of Argentina into Guyana, into Trinidad, into Iran. It was sort of interesting. It made me sort of to Linda's point about weakness of some of the other cases, and I just wanted to know if you could talk about that. And the other one is the Zazi case. So talk a little bit about that case and how it might counter this. But anyway, I turn it over to you to talk about whatever you feel like.
Thanks. Thanks, Karen. I think I can address your points using examples from those cases and others. First of all, I just want to say thank you for having me here. It's a privilege to be here, and it's great to be back at Fordham Law School. It's great to be here with this esteemed panel. Listening to some of my colleagues speak has been very interesting for me, very stimulating. It's caused me already to deviate from the notes I have in front of me. And I think that's really the value of forums like this, so I appreciate this opportunity. I'm also very curious to see if I'm in this book. But I'm going to wait until after the presentation. So I wanted to tell you what my perception is of the role of a federal prosecutor in terrorism cases, and ways in which I think that has evolved, and ways in which I think it's been constant over the last few years. I've been involved in it for about 6 years, and I've done terrorism prosecutions, and I've done other types of prosecutions, gangs and drugs and frauds, and so I have some sense of how those two types of cases compare. I think that we can all agree from what I've listened to today and heard elsewhere that it is a very difficult job to do perfectly, counterterrorism. And the reason why is because there's zero tolerance for completion of crime. At least that's my perception, and I think that's a perception shared by most Americans. So traditionally, when I try a murder case or a drug case or a fraud case, you could tell the jury about the completion of the crime, and already there was a certain exception. Murder happens. Drug dealing happens. Terrorism, we don't want that to happen. So what that means is by design, by intent, we try to prevent the completion of the crime. And so that brings into the prosecution analysis the encoding crimes, or what is an attempt, what constitutes a conspiracy. And so the analysis in many of the cases where we've done successful disruptions through criminal prosecution, the real analysis for the prosecutor and the agents and the other people who've been invested in the case is the same question that I think has been raised by this panel. Has this person demonstrated the intent to commit the crime, and have they committed a substantial step within the legal framework towards the commission of that crime, such that we can all agree that this person is a quote terrorist and not someone who has been caught in a sting or been a victim of a jailhouse snitch or something that we would all want to avoid. Right? So that is a conversation that we have in every case, and we have it more than once. And working with my colleagues at the FBI in terrorism cases, I think there's an unusual level of collaboration early in investigation between the prosecutors and the investigators as early as possible. Because the FBI uses a tremendous amount of resources to prevent the commission of terrorist acts. People and technical tools and different legal authorities. And so the question is always, when do we act? And that's a hard question to answer because we have seen young men radicalize and then de-radicalize and have never taken action. We've seen other young people radicalize very quickly and then take terrible action. For example, the Boston Marathon bombing is an example of one where we didn't prevent a crime of terrorism, and it was terrible. And so it's a very, very difficult question from a prosecutor, and I'm asked it every week. Where are we with this investigation? Is it time to take it down? Do we need more? And what are the risks associated with it? The investigations also involve a lot of other government agencies who have basically decided they aren't prosecutors, who don't know anything about the way the legal system works. And I see my role as a prosecutor as to try to explain to other people what will happen if we choose this option, if we try criminal prosecution as a way to disrupt a terrorist event. And people are very anxious about that. People are very anxious about prosecutions of terrorism cases in general on both sides. What if you have a terrorism trial in New York? Will the sky fall? I think the answer to that is no. But there are still people who feel that way. And conversely, there are people who are dedicated to combating terrorism who are who the notion of discovery in public trials gives them chills, because the fear is that if we reveal too much about the way that we catch terrorists, then we may win the battle but lose the war, because the enemy will adjust. And so for a prosecutor, the challenge is to say to your partners in the FBI and other agencies, we've established an evidentiary benchmark, which is the right and reasonable one, which will keep people safe but also make use of your limited resources, and that the public will be comfortable with. And also to say, we recognize that in every investigation, prosecution isn't always the right option, even when tremendous resources have been brought to bear there. And the options include everything from military action on the one hand to, as Andrea suggested, social service intervention on the other hand. And that's a difficult challenge. And it's not one that we always do perfectly, but I can tell you that in my experience, it's something that people think very carefully about, at least in my experience, and here in New York and the partners that I work with. People are not blind to these tensions and to these challenges. Talking very, very briefly about sting cases and cases involving undercovers, you know, I've been involved in some terrorism cases that involved UCs and stings and others that didn't. And I think from my point of view, the purpose of an undercover is really to try to help vet that intent. And the problem comes, I think, the criticism is fair when an argument can be made that the undercover or the informant starts to drive conduct as opposed to vet conduct. And I can tell you in a recent case that we just did, we decided to task the undercover to try to talk the defendant out of committing the crime. For a number of reasons. Mostly because we thought it would be the strongest indicator of the defendant's commitment to act. I don't know that that's the right technique in every case, but in our case, what it revealed was an unwavering commitment to commit the crime and some action that followed. And that gave us all a lot of comfort in deciding that that was a good time to charge, when we actually couldn't talk the person out of committing the crime. And that's, like I said, not necessarily the right technique for every case or every investigation, but in this case it was. And It gave us a lot of comfort, and I hope it would give comfort to some of our critics who suggested that we're always the ones pushing the person towards the commission of crime. I think that in terms of the evolution of these cases, while we have done a number of terrorism cases here in New York, in the Eastern District, the Southern District of New York, and other districts, there is a certain amount of familiarity now. Our bench, now our judges, they know what the Classified Information Procedures Act is now, but they've never heard of it a few years ago. You don't have to explain to them what the elements of a material support charge are. So there's some familiarity here, but the cases are still far from routine. We are still talking about doing something for the first time. And so there's still a lot of anxiety and uncertainty in this practice when we talk about using certain legal tools or certain strategies. So I can tell you that we are certainly not complacent about the counterterrorism effort. We're not complacent about the authorities and the tools that we use here. People are trying, I think their best in my experience, to be careful and cautious while keeping in the back of their mind that if we fail to act, the consequences could be severe. When you prosecute these types of inchoate offenses, it's kind of ironic because you measure your success by what doesn't happen. And that's a hard thing to measure sometimes because it's difficult to know what would have happened if you hadn't. So that's sort of my overview of my perspective as a prosecutor. I'm always eager to hear what people think because I think that really does fuel the way we think about what's expected of us, what America expects of us in the counterterrorism effort, balancing fundamental constitutional protections and American liberties with the need to protect the public.
I want to come back to something that you said about social services, because I think it was Andrea raised the notion of interventions. So, and I was surprised to hear that because we haven't heard that before. Is there a path of intervention that, there are two frustrating things about looking at terrorism prosecutions that always makes you feel as somebody not involved in the process. One is there's so much classified information that as much as that we don't know what we don't know. And you do know supposedly what we don't know. And so that's one difficult thing. And the other difficult thing, and it's related, is that we don't know what cases you decide not to bring. And I actually think it would be a tremendous public service to say, here's a case, not specifics, that we decided, whoever we did, not to bring. So I'm asking you about that particular group, that social services group. We never hear about that. Is that something that's developing, that's coming? Does it work? Is it worthless? How do you understand that?
Well, so I have to know.
You're speaking for the whole world.
Sure. No, look, I have to know my role, and I'm not a social services person. I'm not a psychologist or a psychiatrist. So I have to know my role, and of course I have to look through the lens of a prosecutor in making charging decisions. But part of that, just as a thoughtful person, you have to rely, of course, on your own life experience, and you have to rely on the information that you have and the options that are available to a person. What becomes difficult for us, and I think I can answer both of your questions in sort of the same way, is that many of the people who become of concern to the counterterrorist effort are young men, right? They're young men who find the call of jihad appealing for one reason or another. And we learn about a lot of these young men through various means, some through human sources, some through different types of legal authorities that allow us to conduct surveillance. And we watch them. And we have made judgment calls at times, I can tell you without getting into specifics, that an individual had enough of a support network that they were likely in our view, or at least it was plausible in our view, that they were just as likely to kind of de-radicalize as they entered into a different stage in their life, whether or not that related to employment or family or education, that it gave us pause in escalating the investigation. In other words, actively pinging or probing the person. So we watch. Now the downside to that is there's a lot of people to watch, right? And so you try to make these judgment calls, and you try to make them based on your sort of common sense and personal experience. But we're not social services professionals, right? And so, and it would be not feasible, at least in my experience, and I would certainly be open to hearing suggestions about this. But when you learn about these people and the facts surrounding the investigation through sensitive sources and methods and classified tools, it could compromise, right, the ability of the U.S. government to conduct investigations like this. If, for example, a target made a phone call and said to his friend, I'm thinking about joining jihad, and the next day a social worker knocked on the door and said, here's a pamphlet about the dangers of jihad, right? You know, that might send off alarm bells. So I don't know how feasible that is, and I'm not aware certainly of cases, and maybe some, I'm not aware of cases where we dispatch a social worker or a psychologist as part of an intervention strategy. But in listening to Andrea and trying to expand the range of options here, you know, I tend to focus in working with the proactive counter to terrorism. You know, we say, well, are we going to use a DOD option? Are we going to use an IC option? Are we going to use a prosecution option? Recognize that there are other ways that people get off the path of violence. Those aren't, you know, that's not my area of expertise. But you do make judgment calls at times. And I can tell you assuredly that there have been cases that we've watched for a long time. And we've seen people essentially de-radicalize, become invested back into society with a support network. We have, I will tell you, reached out to family members in investigations and sought the assistance of family members with defense counsel, I think aligned on the same page, to try to help a defendant in a precarious situation navigate to what we thought was a mutually beneficial result, which can sometimes mean no jail time. You know, like we've had terrorism defendants who, to this day, have never spent a day in jail because there was an intervention with the help of their family and their defense counsel and others. So I do think we need to be open-minded about these options. I hope that answers your question.
Can I respond specifically to that one point? This idea of the pamphlet about jihad, it's very funny, but the reality is what happens is that an informant often goes to the door and says, do you want to talk about jihad? Jihad means blowing yourself up. And instead, so yes, you're not going to send a social worker, just like the informant is going to say, I'm here on behalf of the FBI. But the jihad in particular, we've seen time and time again where there are, for example, new converts to Islam who walk around saying, I don't really understand what this means. I'm struggling with the notion of jihad, which, as many of us know, doesn't necessarily mean violent action at all. And the person either working for the government or acting at the behest of the government says jihad means the following, and it involves violence and involves criminal activity. So as much as you don't send in a social worker, you often do send in an informant to do the reverse of what potentially could actually in order to benefit the society.
I want to ask John a couple of questions that we're just going to keep you here and ask you all. My real question is kind of following up from this part of the conversation. What's happened in the FBI in terms of thinking about the difference between using a trained agent and using an informant that is pleading a deal for something else? You know, and you can use your language because everybody uses something else. So, but as I think of it, the difference between an undercover, which is one that belongs to you, and somebody who you've deployed to act on your behalf. And I'm wondering about a couple of things. I noticed that I was reading through some FBI things the other day about, you know, attempts to get more people who understood the countries that these people came from within the FBI, more people who spoke the languages within the FBI. And there aren't really any ready statistics on this. I'm just wondering what's happened in terms of who's doing the work and how you think about that, and if you think it affects the ways in which these investigations are put together and played out.
Well, to answer the first part of that, whether we would use an undercover employee or a confidential human source, a lot of that ultimately just depends on who has the access. Obviously, the FBI, prosecutor's office, we want to use undercover employees when we can for veracity and a lot of other issues. One thing that you mentioned there's been a real effort within the FBI to hire individuals from different communities, different backgrounds. Obviously, the last 12, 13 years since 9/11, we have focused on a number of threats, those being terrorist threats, and look towards those communities and individuals whose parents may come over and they're U.S. citizens, get them on board, not just as investigators and special agents, but linguists, analysts, and to give us a better understanding of culture. A lot, back when I first started, and even before 9/11, there was a lot lost on understanding the cultural differences. Individuals that were investigating for terrorism activities. Some of it back then, like she just mentioned, jihad. Jihad can be a lot of different things. What's the true definition of jihad? Well, it's finding yourself, right? It's doing something to further yourself as a God that helps others. Jihad we hear a lot though. Jihad we hear with some of the investigations we were, jihad is to go do a lot of that. So I would say pre-9/11 or just thereafter, jihad was automatically you're going to do a lot of that for some different purpose. Now there's an understanding that a lot of people that we do bring in different cultural differences, and I think that's helped our investigations not to go down certain pathways that we would ordinarily, or back in the day, wasted resources and time on. So I think that's helpful. I'm not sure if I'm okay. And then I don't know the statistics off the top of my head as far as, let's say, Middle Eastern ethnicities that are agents or analysts or linguists, but I will say a lot of linguists, obviously, some of the U.S. persons or the contractors, they're not away, have helped a great deal over the last 12, 13 years. We had a lot of problems right around 9/11 not having enough resources with having linguists and language abilities to help us, basically translate a lot of the stuff that we were picking up. That's been a huge help in the last 5 to 7 years.
One thing we should talk about before we open it up to the floor is this issue of who gets targeted, and if that's changed over time. As you say, there's been kind of a learning curve about what behavior leads to violent behavior and what behavior might not, like you just spouting out something. And I'm wondering about this thing that Andrea brought up in the beginning about people who are mentally unstable, people who are indigent, people who are, and you brought it up, young. And to some extent, the population crosses over with the regular general criminal element, the 18 to 25. But we've seen a number of cases in the past couple of years where the terrorism defendants have been really young. And so I'm just wondering if there is, how that just figures into your thinking, how that's playing out.
Sure. For us, if the threat comes in, automatic things are going to happen. We receive threat information. When a case if we receive threat information, 3 things are going to happen. We're going to open an assessment, we're going to open a preliminary investigation, or a full investigation, depending on the level of that threat information. What we don't have in the beginning of the investigation is this individual emotionally disturbed? Is the individual? We don't know that. And we may not know that for a long period of time as we go through the investigation. Even when there may be some questions on the person has some emotional issues, it doesn't change the fact that he or she is still not a threat. We still have to operate accordingly, because that individual still is capable of hurting the general public, and we still have to operate within the confines of our rules and regulations of the Constitution. And we do we're very sensitive to those issues. There's been a lot of press through the years on the sting operations, the entrapment issue, individuals who don't have means or methods. So we do look at those very carefully. Really, when we're in the FBI Academy, the Religion Academy down in Quantico, there's training on this, and agents receive regular training on these issues through the years of their career. But with regard to your question, we don't have the luxury in the beginning, and definitely through a lot of the investigation, to know what the emotional situation, mental situation of the individual is. And then once we may have some indicators, if they are there, we do still have to do our due diligence.
The only reason I think that's right. I think that the thing I wanted to bring up was there's some connection between vulnerable and mental illness is one thing, indigence is another thing. vulnerable in youth seems to me to coincide with what Andrew was talking about in terms of intervention. And I just wondered if you or Seth had any sense of that piece of the issue. I mean, there's a case, you know, the Muhammad case in Portland, which is not here, but, you know, I always got the feeling reading about it, talking to people, that actually that investigation had started when he was really young. And so I just kind of wondered how that figures into how we would want to be thinking about these cases in terms of what, you know, if you're going to intervene, I think, what if they're 15? You know, how does that function?
I'll just say a quick part on that. As far as the FBI, we do with our investigations, if somebody is a minor, there's certain rules and regulations, certain things we need to do.
Yeah.
You know, as far as investigating that individual, you know, if there's an interview, there's certain, you know, notifying parents, you know, notifying others. You know, so we don't just take, you know, steps in a vacuum where we're not operating and treating a youth as an adult. But I'll let Seth answer the rest of that.
So, you know, I think it's difficult because we talk about youth as a mitigating factor, and I think the reason why we talk about youth as a mitigating factor is because there's a notion that the youth are more susceptible, right, more easily influenced. But the problem for us and the challenge for us is that if you look at the terrorist propaganda, it's quite powerful. And some of the terrorist lecturers and speakers are quite charismatic. And so what we've seen with some of these young men is that when they access this media and they listen to the lectures on Mar-a-Lago or another speaker, it has a very powerful influence on them. So you have to say to yourself, if I have a person now who's at a crossroads and they have shown an interest, a desire to follow these teachings, to embrace this media, you have to ask yourself, well, how am I going to disrupt that? How am I going to get that person away from that preoccupation with something that I think, in our view, would always be destructive and dangerous and violent, recognizing that it's also very powerful. Is a knock on the door, you know, by an agent or an intervention by a parent or a social worker, is that going to be sufficient to counter the draw of that very powerful propaganda? And I think it's a very difficult assessment to make. We had a case with two young men from Brooklyn, similar backgrounds, left together to go fight jihad and wanted to attack U.S. troops. And one of them, along the way, de-radicalized essentially on his own. Got a little homesick, reached out to his family, reconnected, and abandoned the plot. The other young man made a martyrdom video, went beyond mere preparations to committing an attack. Both very young, both similarly situated. So it's difficult to know which way that sort of vulnerability to manipulation, that susceptibility to influence is going to cut. When you know, FBI agents aren't social workers, and we have a limited, I'm sure we have many great social workers here in New York, but when you think, what do you need to do to balance the call that these terrorist organizations so readily disseminate by the internet and other ways? And I think that's really the challenge. Without some support system, I think it's, and certainly not speaking as an expert, but where we've seen people sort of de-radicalize, young men de-radicalize, it's been because they were invested in something else, school, family, some other influence in their lives. You know, we, the U.S. government, unfortunately, can't be that influence in every case. So we have to make decisions about, you know, reasonable decisions about when to intervene through some type of action.
Linda, I want you to talk a little bit just about, in the context of mental illness and culpability and how to think about it and how to prosecute a case, obviously. Because, no, Dr. Siddiq is a very unusual case. She's female. She probably would have gone to Guantanamo, but she's female, right? She was a very difficult courtroom presence, and that kindly. And she did not want to be classified as mentally unstable. So can you just talk a little, because it's not just about how law enforcement sees these defendants, it's how they see themselves. And I think you can just talk about that.
Well, I mean, Dr. Siddiqui was one of the most unique clients I've ever defended. She was, in my view, and I'm on the record saying this, was clearly damaged. I don't know exactly what contributed to that. There are a lot of stories about Dr. Siddiqui, including that she was the gray lady held by the government. But what this does, of course, one of the first things it does is it erodes trust in the defense lawyer, because you're trying to establish yourself with some sort of credibility to someone who doesn't believe who you are, doesn't believe in the system, and really sees themselves victimized in a very righteous way. Dr. Siddiqui, there was a lot of litigation about that she was not competent to stand trial. Lots and lots of motions were filed. After a year of continuous denials from the bench on that issue, she was found competent. Then we were brought in to try the case. Dr. Siddiqui, throughout the trial, would stand up and just address the press in the courtroom. At one point, I was, and I think this is also a matter of record, one of the reasons she wanted me on the case was because I was female and a Latina. And at one point in the trial, in the middle of the trial, she addressed the jurors, some of whom were Hispanic, and said, I want you genetically tested because I believe you're only passing as Hispanic and you're really Jewish. At which point the judge looked at me as being the only Latin person at the table. And I didn't really have any comment about that, but this was one in a series of, we would constantly move for mistrials and again reassert our emotions that she was clearly incompetent and there were several issues. So, and she was one of the more extreme examples of that. There is no good answer in dealing as a defense lawyer with someone like that. She refused to be evaluated. She was in complete and total resistance to the whole process. Not all defendants are like that and will be. In fact, some of them want to be seen and evaluated, but this was clearly a very unique example.
We're going to open it up for your questions, so
Yeah.
and you scream out your question.
Okay. A lot of the discussion goes in certain directions based upon the use of language. So when you use a term like vulnerability, you might also take that same term and instead of vulnerability, if you said proclivity, then you would think in a completely different way. Now why do I say proclivity? Because if you think of something like hypnotizability, power of suggestion, how easy is it for somebody to be persuaded to think in a certain way or to feel in a certain way? If you also think, as you pointed out, these are young people, young men at a point in time, some of them maybe don't have money, don't have a way to survive, don't know what they want to do with their life, would like to do something that has a meaningful effect in the world. Second point I'd like you to think about and talk about is you're focusing on proclivity. I prefer that term to vulnerability because proclivity allows you to think through the range of reasons why people may have a proclivity to be violent. And you're only thinking about it that way. What about thinking about it as many of the young people who get involved in terrorism think about it in terms of a grievance and whether or not that grievance has validity. So for instance, for many of the young people who are involved in terrorism in the Middle East, they believe that they are doing something in the service of justice, that an injustice is being done. Whether it's because they live in a government where the government is a tyranny that's been supported by the United States, or whether they think they're Palestinian and they own the land or whatever. So the main point I'm trying to make is think of this now in terms of grievance.
Okay, but I I get the question.
Okay.
I'm gonna pose it a little differently. Which is, because, it's more of a statement, so let me try to turn
Sure.
it into a question, which is that the one thing about terrorism that is really challenging, and terrorism prosecution, investigations, and critiques, is that it comes up against American foreign policy. It's not like you're operating on your own in your own criminal justice sphere. There's State Department issues, Defense Department issues, live war issues, not live war issues. How do you think about those? Is there constant conversation with the powers that be in Washington that are not law enforcement? How exactly does that fit into it, as opposed to a root cause, but just to get a sense of how much do you feel part of in a larger conversation about foreign policy that, all of a sudden inside the criminal justice system? You both of you can do one, whatever.
Well, certainly the conversations about bringing charges in a terrorism case, there are a lot of stakeholders, and you've identified many of them. Because particularly when you're talking about, for example, charging a foreign actor and transferring them into the custody of the United States for prosecution, that implicates issues of diplomacy and foreign policy, balancing of the potential risk of litigation. So certainly that is part of the conversation. What I try to stay focused on is that I'm prosecuting a crime. And there are elements to the crime, and that has to be the starting point. So while ideology is interesting, the politics is interesting, the diplomatic issues, those are all interesting. I think for criminal investigators or national security investigators of the FBI and for prosecutors, what we try to stay rooted to is, does the conduct fit the elements of the crime, and will criminal prosecution and hopefully conviction and sentencing achieve a prosecution goal that's consistent, or not inconsistent, I should say, with the other interests that are out there. And that is always part of the conversation. What will be the perception of our foreign partners? What will be the perception of the American public? What is the collective will to bring these types of cases? But you can get lost in a morass very quickly if you think about it that way. At least I feel that I can. So.
It's a little bit different for the FBI though, because the FBI functions abroad, has offices abroad, needs cooperation abroad. So how much do you feel, I'm curious how to think about the fact that you're part of an international conversation, and then you bear the responsibility for these investigations in a way that you have conflicting roles or not?
Well, yeah, sure. So each agency has a responsibility, right, that they need to follow through on. With regard to foreign policy, politics that is around into the environment that we work in every day, the FBI takes it very seriously to focus on our responsibility. Our responsibility is protecting people in this country and its national security interests. There's a lot of things that go on as far as politics of cases and overseas. Obviously, everybody knows the long history of the CIA and the FBI, and sometimes we can butt heads. We have different cultures, we have different interests, we have different responsibilities. That does exist. We have to have social and emotional intelligence to work through some of those things. But at the end of the day, we can't get caught up in all the politics and foreign policy aspects. We try to just make sure we're operating within the confines of the Constitution, and we're doing our due diligence as far as protecting the national security interests of this country, the people as well.
Yes, I just wanted to say to the gentleman's point, and with respect to my colleagues here, politics does play a part in a lot of these prosecutions, and it's often the defense lawyer who has to address those politics in terms usually of a speech context, right, of a First Amendment context. Because quite often the evidence that is used, that the prosecutor uses against a defendant, are his words, are his speeches, are the websites that he's accessing, are his affiliations, all which we would say are protected, right, but they are used as evidence. And the prosecution would say, well, this is evidence of his intent. The question is of his intent for what? But make no doubt that there are some prosecutions that are highly political, and these international questions and issues come up in the government's case in chief, the defense lawyer has to address them.
And I would just add that the impact is also global. And Human Rights Watch works in 90 countries, and for this report, we didn't translate the entire thing, but we translated our summary and recommendations into a number of languages. And, for example, I got an email from our researcher in Morocco saying, your report is all over the Moroccan press every day. Everyone is fascinated by this. And we think in Article 3 terrorism trials, and who knows what that means yet. In Morocco, there was a huge impact. And these cases are widely followed around the world. And that is, of course, not what these gentlemen need to think about when they're working on their cases, but there is that impact.
More questions?
Linda had mentioned her view of it as criminalizing what defendants thought, and I agree with that in a lot of these cases. And then was somewhat startled by the way Steph was talking about radicalization, because that's of course exactly what that is. And in fact, the FBI's trains that there is a direct line from certain thoughts to becoming a terrorist, and that once you have these thoughts, you're on the path, which is what I think drives a lot of informative cases, is that there's this theory that if you have these ideas, we have to stop you, when in fact that theory has been completely undermined by every empirical study that's ever studied terrorism, and yet it persists. And when I was at the ACLU, we uncovered a lot of really incredibly bad training at the FBI, but pointing to that radicalization training specifically, saying, this is causing a lot of problems. And that was one element that they wouldn't remove. Do you know the status of the corrections for the training? And is this theory that is empirically unsound still driving a lot of these prosecuting decisions?
Well, it's coming from the FBI, I mean, I'll have to disagree with your opinion of the
I was in the FBI.
I know you are. Yeah, I know you are. I'm going based off of my own experiences. So, I mean, I disagree. We don't teach our folks to make, cookie cutter decisions on based off of one.
I can show you the textbook. It's an FBI textbook that teaches.
Okay,
Again, I respectfully disagree. We go through great lengths to make sure that our undercover employees, our confidential human sources, as Seth pointed out earlier, don't drive the information. They try to go about vetting the information. I know that's something I stress with my folks. I know that's something my SAC, William Sweeney, stresses constantly when we're out there. We're operating these sensitive sources.
Just one example of that is actually the Hosam Samadi case that I mentioned before. We have in the report an example where you can see the agent saying this places him at X place on the radicalization scale. So we're watching him go from here and he's going to end up here, and that's part of why that's investigated.
I'll just respond briefly because I think it might be useful to define terms. By my use of the word radicalization. So I think I said one of the challenges for us was to figure out what somebody's intent is and what act would constitute a substantial step towards the commission of the crime that's under investigation. So when I say radicalization, just to be specific, what I'm talking about is when we've seen someone, maybe a convert, recent convert, or someone of a particular faith, start to investigate that faith, and then follow a thread of that faith. For example, the lectures of Anwar al-Awlaki or others who have offered an interpretation of Islam, for example, that young men have a religious obligation to fight in defense of the religion and what that means in the modern world. So the radicalization, I guess what I mean by that is where we've seen targets of our investigation become increasingly focused on the teachings or the lectures or the media of a particular group that advocates violence to that end. And then that often can be useful, I think is useful, in trying to determine the significance of an act in context. So for example, if we see someone who is showing increased focus on what I would call extremist interpretations of a particular faith or its obligations, what I would characterize as a radical view of what their religious obligation is involved. and then we see the person, purchase a plane ticket to one of the regions in the world where we've seen these teachings indicate that there's a religious obligation to fight, for example, Somalia or Afghanistan or Iraq or Pakistan or Chechnya. It gives context to that. And so I can tell you that our sort of benchmark in many of these cases has been, do we see, an unusually high focus on this type of advocacy towards action and religious obligation, coupled with real action. They buy a ticket, they go to a camping store, they pack for overseas, they get rid of their worldly possessions, and they show up at JFK. So, to me, that makes sense. I haven't read the textbook. I don't know what it says. But that's what I meant by radicalization, and if you have a different view of the reliability of that, I'd be curious to hear more about it maybe after.
Absolutely. Seth and John, how long do you let this play out, right? How long, you re-up the assessment, you break, when you say, okay, we're done? Because the people across the street, in my PD, we follow people for 10 years, right? They don't have a dialogue. Okay. Where do you draw the line? When do you say, okay, 2 years is nothing is going to happen. You spend an enormous amount of money. I can't imagine what full-time surveillance costs for the FBI. It's incredibly resource intensive. When you look for it.
I'll respond to that just because the microphone is closer to me, and I'll hand it to you. Look, I think it's a very difficult question, and I hate to give you a lawyer's answer, but it depends, right? I mean, you have the FBI invested in an investigation that may, as you say, go on for years. And in my experience, at least, look, if you're going to act domestically, right, the FBI needs the assistance of a prosecutor's office to arrest someone. So we have conversations, sometimes that go on for a long time, about what we sort of collectively think is the right thing to do at the right time. And it's hard to know for sure. I mean, people lose a lot of sleep, the FBI in particular, because of the responsibilities that they have to use those resources wisely. So, I was asked this question very recently, and my response was not satisfactory to the person who does it, and I doubt it will be satisfactory to you, but you have to look at what the legal framework is, right? In an inchoate crime where there's a conspiracy or an attempt, and we're looking for a benchmark to charge, there has to be a clear indication of intent to commit the crime and a substantial step towards completing the crime. And we have conversations with the FBI all the time as a difference between mere preparation and a substantial step. And when we talk about conspiracies, we talk about acts in furtherance of the conspiracy and proof of the actual formation of that conspiracy. So, look, we're very cognizant of the competing tensions that we face. One, if we act too soon, we will be criticized as being too aggressive, and if we wait too long, then Americans will die.
Let me ask one last question. After the Boston bombing, the SEC, they put out a statement saying, look, we do 1,100 assessments. We go through an enormous amount. I think I heard that New York belongs to 1,300 assessments. It's an enormous amount of people. Can you give us a sense of how many of those assessments actually move forward using these state? Okay, I'm not on specific numbers, but is it a substantial amount? How much thought actually goes into it? Okay, now let's move from assessment toward completion.
Great time to pass it.
So both good questions. With regard to the first one, just real quick, I think it's probably a question you can't answer definitively. I think each investigation has certain nuances and different things that go on that trained investigator, we take pride in training our agents that come in, and we do a careful job of selecting our task force officers as well. We have to rely on the information, the evidence that's out there. We do have certain boxes that we need to check within an investigation, and those things automatically have to be done. If you go through an investigation and you go through these certain investigative tools and resources that you use, and you don't turn something up as far as nefarious activity or a nexus to terrorism, in most cases, those cases would be closed unless there were significant outstanding factors. As far as assessments, yes, the New York office does a tremendous amount of assessments in most of the FBI. By far, we're also the largest office, makes sense. As far as the statistics on what actually gets turned into a preliminary investigation or a full investigation, I don't have the actual number. I will say a great deal of effort does go into the assessments. We do have a pretty good gamut of resources and tools that we can use within the assessment framework. The important thing with the assessment, and I think this is important for everybody here to know, is that was kind of created to kind of help vet out some of the information, taking the least intrusive methods of investigating somebody without going right to a full field investigation, which would happen quite often back in the day. This gives us a good avenue of taking a look at somebody, doing the appropriate steps as far as getting to a point where we can say, hey, you know what, this individual really is not associated to terrorism, there's no nexus here. We can close them down without having a number of different resources or methods that we would use under a full investigation and have that stuff out there within the file. I don't know if that makes sense or not, but as far as the numbers that become fulls or preliminary investigations, it would depend upon whether we could answer the questions under the assessment. Is this guy associated to a terrorism group, or is this individual radicalized? Is this individual a homegrown violent extremist where we feel is a real threat? So I hope that helps a little bit. As far as the numbers are, I can get that maybe offline.
Last question, Josh.
And forgive the preamble, but I need to contextualize this into a question, which is that it's not directed.
Actually, we're going to have 2 more questions.
And it's not. It's going to be directed. First, it's Seth, and I don't mean to put him on the spot because he's, in my experience, not different than any other prosecutor I know in the context of the question. And you may have to do something with him someday, so I don't think to put him on the spot. But it's also really for Andrea too, in the sense that I have not read the full report, but I'm not sure that this is covered in the report, which is that this has been presented to some extent as an all or nothing proposition, which is either prosecute or not. And there is a section of 2339B, 2339B little c, which authorizes the Attorney General to get an injunction against someone considering material support. It's a civil provision that permits a middle ground that has never been used, ever. And I've written a law review article that no one has read, probably because it's too long and my visions of turning it into a book that no one will read. But the point is several. One is instead of a sort of knock on the door social worker or FBI agent, there would build within itself an institutionalized social service network, just as we have in problem-solving courts for either mental health or drug courts or things like that, that would grow within that process and create a mechanism for supervision and prevention that, to me, is much more powerful, much more effective than simply prosecute or not prosecute. I also recognize, and this is a question also to Linda, to a certain extent, and to John, because it manifests itself in other ways, which is, I recognize that using 2339B little c would involving more people at the lower margin. In other words, some of the people who the FBI passes on and the prosecutors pass on would come within probably an injunctive provision because it would be easier to get at an earlier point in the continuum. So it would involve people earlier. But on balance, I still would favor it for a couple of reasons. One, which is I think it's a much more effective use of soft power. I think it's a much more effective way to engage communities in terrorism and counterterrorism without the prospect of 15 to 20 to 25 to 30-year sentences that exist. Also, I have at least 2 clients who cycled back twice. In other words, so deferring on prosecuting them the first time didn't help because their rhetoric and their activities, not criminal activities, but their rhetoric in a mosque, in the community, put them on the radar again, and then they were approached by an informant again, and the second or third time, they were prosecuted. And I would prefer at the time, at the first time, even though they had not done something criminal, if they had been subject to an injunction, I would prefer that to the 10 and 15 years that they're doing in federal prison. And the last part of it is also that the FBI does this to a certain extent to its credit. I've had 3 instances in the past year of representing people, 2 of whom
a counsel to actually submit to interviews. And it's kind of this wink and nod version of, look, we got a complaint, you came on our radar, we need to vet you in some respect. And for two of the people who clearly did not have any exposure, my advice was sit down with them. They will be able to cross you off the list, and it will be to your benefit rather than to be harassed and consider yourself under. So why not 2339B, and and again, not to put you on the spot in the sense of as a concept, because it does exist, can we use that?
Before you answer, let's go to the last question, and then each one you can speak to answer whatever parts of your
My question is, what do you think the responsibility of the Muslim community as a whole? Is it becoming a partner, not only with the FBI, but with other law enforcement in proactively helping? And I say that with 25 years, well, 28 years of experience in the FBI. I was the case agent on murder of Meyer Kahani, which morphed into the World Trade Center case. My informant penetrated the blind sheikh and became his bodyguard and blah, 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 and so forth down the line. I testified the first Trade Center case plus the embassy bombing case. And the reason I say that, just a little bit of bona fides, but after I left the JTTF, I went into community affairs. And I would go out to the Muslim community and I would tell them who I was and what I did. I got a lot of bad press back in those days. I went through all those things that you said. We had bad informants. I had to explain why my informant didn't entrap Sheikh Rockman. I was a bad agent. We went through all that in the trial process and we prevailed. And I don't mind it. It was a good exercise, even though it was uncomfortable. But when I met with the Muslim community on several occasions, I said, you're complaining about heavy-handed FBI or police, and there are things that we have to watch. Having an informant that's driving a case or wants to get off on a drug charge, he'll find a terrorist for you if he has to, because it's in his best interest to find you a terrorist case. We as good agents, good prosecutors, good supervisors, have to nip that in the bud. But those are all human nature things. Finally, I told the guys, the imams at different mosques, if you don't help us with terrorism, somebody has to do it for you. In other words, if you don't engage with us to find out the young person who is going down the wrong path, and they know who they are, but there is still something holding them back from going to somebody that will tell us or the NYPD, this kid's going down the wrong path. If they did that, 95%, I believe, of the terrorism cases could be nipped in the bud with stuff that Andrea is talking about. The first World Trade Center bombers, I told 3 of them, you're going to wind up in jail one day. Please don't do that. They were all former Mujahs from Afghanistan fighting the Russians. I told them you're going down the wrong path. We think Western. If the FBI came to me and I was dealing drugs or doing something wrong, I would cease and desist the moment that FBI agent left. If you've been in combat in Afghanistan or Bosnia or Chechnya, a harsh interview by a couple of polite FBI agents and an NYPD detective is not going to stop you from going forward. That's just the way it's my experience. Those guys, I locked them up after the Trade Center. I knew who they were once we found the VIN number because it was simple. But I talked to them beforehand, and they were not children at all.
Final comments from anybody starting with that?
So first, Josh, to your comments, look, I think we have to be open-minded to all potential remedies in counterterrorism efforts. And I'm not familiar with 2339 BC, but you're tempting me to supersede an indictment and add it. In all seriousness, I think finding the right remedy for the right case is a challenge that every prosecutor faces. It may well be that is a statute that's applicable to the right case. I don't think I've personally come across that case yet because the cases that I've been involved in tend to involve, I think, people closer to the line of what our last question was about, which is we're scared of them there, right? And so you want to have a tool that has enough teeth to give us some assurances that we've disrupted whatever the plot. But I'm sure there is the right case for that statute, and I hope I find it. to the last question that came in about the Muslim community, I mean, I can say certainly in many of our investigations, community support, both from the Muslim community, the family community, we've had imams, we've had employers, we've had educators. I think anyone who's in a position of influence or a position to recognize aberrant or potentially violent behavior and derail it offers us a tremendous asset in the effort. And I think the point, I think if I took your point, it's that there has to be recognition of the potential threat and a trust relationship between the people in the community who become aware of it and the people in law enforcement and elsewhere who are in a position to address it. And so I can say, we've had some very positive experiences in that regard, and frankly, it sounds like you've had a lot more experience than I have directly in that capacity. So I don't think there's much I can add to your comments.
So I think both your questions talk about community impact, and Josh, you don't need to keep reading 2339B, small c is not in here. Also news to me, but what is in here is the community impact. So my initial reaction to your question was, this report documents violations of international human rights law, whether someone's charged under small c or small b. Doesn't matter, but what does matter, which we also document, and I didn't have a chance to discuss much, is the impact on communities. And to answer your question, why isn't the American Muslim community more engaged? The answer is what I documented in this report. And that's the sort of dangerous cycle that we have here. We have people, I've had imams say to me, why are they not coming to me? Why is the FBI not coming to me and saying there's a young man in your mosque engaged in this nefarious activity, you should do something about it. We had community members saying, I'm terrified of the FBI. And this is something that I found, to be perfectly honest, I didn't appreciate the scope of the problem when I started the work. My co-authors and co-researchers are both Muslim. We talked to a lot of people, particularly in New York and the American Muslim communities here, who talked about the problem. And it sounded a little overblown to me. It sounded like people were overreacting. And then I traveled the country and I talked to people who were just like me, only they happen to be Muslim, and their experience of the same government, living in the same country that I live in, is so fundamentally different that I realized how serious a problem this is. If you want to set aside all of the human rights violations that we documented in these cases, which I hope you don't, just looking at the impact that these types of law enforcement activities and prosecutorial activities have on significant swaths of the American community is really disturbing. And that is reason alone for law enforcement and prosecutors to change their tactics. And the added benefit of that, aside from just treating people the way they should be treated, is likely a greater interest in cooperation, more partnerships, the type of which the JTTF in particular has talked about, the president has talked about. The opening quote in our report is a quote from President Obama talking about how important partnerships are with the Muslim community, the rhetoric behind all of the community outreach that takes place. But it's not going to be effective if people are afraid that they call the FBI to say that their neighbor is engaged in some criminal activity, and the next thing they know, he's in the hole for 6 weeks awaiting trial. He ends up with a 25-year sentence. He ends up in Florence, Colorado in a supermax and can never touch his mother again or hold his child. And these things scare people. They scare people who are part of our communities. And changing some of these very different tactics can have a positive impact on those communities.
So very quickly, I think both of your questions are related because they're both talking about fear, trust, and compassion really. Joshua's question really touches upon a compassionate direction in which to look at some of these cases, some of these, let's just say, young Muslim men who might be bent on nefarious activity, violent activity, and to treat them in more compassionate ways before anything terrible happens, like we do, and as Josh mentioned, the drug courts and what have you. I've talked to a lot of Muslim communities around the United States, and they're all very different. The Muslim communities in Detroit are very different than the ones in Dallas, Texas, different than the ones here. And I will tell you that part of the problems that they have, and I think it's an excellent question, what which you asked, what is the responsibility of the Muslim community? Well, there isn't just one Muslim community, just like there isn't just one, Catholic community or Jewish community. And there's a lot of distrust. There's a lot of prejudice that many Muslims have felt in New York and in other places. That's well documented. And I think that both parties have a way to go to rebuild trust. I'll just say this. You guys, you fine gentlemen, have an FBI Citizen Academy. I happen to know that a lot of Muslims have been in those academies. Heads of CARE, the Council on Arab-Islamic Relations. And some of those are very fine, very decent places, and some of them are just sort of warehouses to recruit moles. That's a problem within the FBI community, not within the Muslim community. But I think that certainly, I'm reminded when I hear about this discussion, the quote that I read recently that I thought I'm going to use this in my opening statement, which is America is the only country that was born perfect but seeks to improve, And I think that's what we need to do more on both sides.
Josh, I apologize, I don't think I can offer anything on the 239B, but see, if that wasn't, able to do that, I'm definitely not going to be able to do that. But, John, and to your point, I think I would say the most important thing going forward, and there's a lot of things that are important as far as us addressing the terrorism aspect and threat to the New York area of responsibility in this country, is the continued effort of trying to strengthen our relationships and our liaison with the Muslim community. I think you're absolutely right. I think a robust and strong relationship with the leaders of the mosques and the Islamic centers is going to be paramount in us being able to deter the next potential terrorist act that may occur. So it's a point well taken, and I think the continued effort there is one of the most important. So, and I would like to also just real quickly thank Karen and my colleagues on the panel for inviting me here this evening to speak to you folks. And thank you so much for coming out and giving me the opportunity to talk about what we do day in and day out. So thank you.
We are 20 minutes over. We've never gone over more than 2 minutes before. I blame you all. But maybe we should just make these things 2 hours. I just want to remind everybody of one thing in the room, that the critics in this room and the people that are on law enforcement that are trying to figure this out all share one thing, a trust and a hope that the Article 3 courts keep these trials, and that we don't start pushing things into the dark. Guantanamo will stay forever, and so you never can forget that. It's kind of in the background, and I think we don't have a good sense of how that colors all of this conversation. So I really just wanted to. Next year, of course, when we meet, it'll all be closed, and so it won't be a problem. But for now, it's still in the ether. So I thank you all for coming. Our next event's on Russia. It's September 22nd. I hope to see you. Thank you.